Once again, good evening. I want to open up with an update about the departure of our former superintendent and athletic director. About 3.5 weeks ago, Superintendent Richard Como and Athletic Director James Donato submitted letters of resignation to this school district. At the time they were submitted, this board provided no comment or explanation. We did so not for the purpose of obscuring reasons for the resignations or protecting these men, not for the purpose of stonewalling our neighbors and constituents, or simply because it was an internal district matter, not out of the indifference of public concern or disregard for the principles of transparency and openness, but because at the time of the resignations were submitted and for several days prior, the facts and circumstances surrounding them were the focus of a criminal investigation by the Office of the Chester County District Attorney. As the elected officials, we are obligated and accountable to various interests. We are accountable to you, our constituents. We are accountable to this district and our students. And we are accountable to the oath we swore upon taking our offices to uphold our Constitution and the laws of this Commonwealth. In so doing, we pledge our full cooperation to the District Attorney's investigation, providing whatever information was requested and following the lead of his office by maintaining our silence so as not to compromise, obstruct, or otherwise interfere with an ongoing investigation. Our colleague, Dr. Tanya Timms-Taylor, was recently quoted as saying this board's position was not silence, but responsibility. And indeed, we believe we were acting responsibly by maintaining our silence during the course of this investigation. But given the fact that this district attorney's office is now commenting on these matters publicly and has advised that we are free to do as well, we will provide a full account of recent events. I will let you know this is long and it's lengthy, but I think it's important for me to be able to explain to you the events and how they happened and the dates and so forth. So please, it's long, it's lengthy, but please let me go through it. On Friday, August 16th, Dr. Taylor was contacted by district employees regarding allegations of racist and sexist text messages allegedly exchanged between Mr. Como and Mr. Donato. Upon receiving this information, Dr. Taylor immediately contacted our solicitor, James Ellison, and arranged to meet with him the following day, Saturday, August 17th, in Coatesville. At that time, both were presented with a cell phone which purportedly belonged to Mr. Donato and allegedly contained the inappropriate text messages, but neither were provided a written record of them at the time. Dr. Taylor subsequently received a written transcript of the alleged messages the following evening, Sunday, August 18th. Upon receiving them, she again contacted Mr. Ellison and subsequently Board Vice President Richard Ritter and myself to request that we all meet the next day, which was Monday, August 19th. All agreed to be present for the meeting, with me participating via conference call because I was traveling at the time. At the August 19th meeting, Dr. Taylor produced a 50-plus page transcript and provided an account of its contents based upon her accuracy review. An immediate investigation was ordered on the spot, said task being assigned to Attorney Ellison. That same day, Mr. Como was confronted regarding the allegations, admitted to exchange some racially inappropriate texts and jokes with Mr. Donato, but did not confirm the contents and its authenticity of the transcripts within Dr. Taylor's possession. At that time, the cell phone that allegedly contained the original messages was retrieved from the district's IT department and placed in Attorney Ellison's custody. The next day, Tuesday, August 20th, members of the district's personnel committee were summoned to the district's central administration offices and apprised of the allegations and resulting investigation. At that time, Mr. Como again admitted to the exchanging some racially inappropriate texts and jokes with Mr. Donato, but did not confirm the contents and authenticity of the transcripts. Attorney Ellison met with members of the personnel committee the following day, Wednesday, August 21st, and advised that he believed it was necessary to secure the services of a forensic examiner for authentication purposes. Mr. Ellison was directed to proceed with retaining a forensic expert while Dr. Taylor maintained possession of the transcript until Attorney Ellison could secure a forensic original from the cell phone for comparison and authentication purposes. Excuse me. The following day, Thursday, August 22nd, Attorney Ellison was contacted by the District Attorney's Office and requested to relinquish custody of the cell phone. Attorney Ellison advised that the cell phone was central. Okay, I'm going to start off with that same paragraph. The following day, Thursday, August 22nd, Attorney Ellison was contacted by the District Attorney's Office and requested to relinquish custody of the cell phone. Attorney Ellison advised that the cell phone was central to his personal investigation and he was not inclined to relinquish it to the District Attorney unless there was a criminal investigation which would compel him to do so. In response, Attorney Ellison was told that there was an investigation regarding potential kickbacks involving high school football camps which were unrelated to the district. Given this assertion, Attorney Ellison requested a few days to have the cell phone forensically imaged before releasing it to the District Attorney's Office so that he could proceed with his personal investigation. His request was denied. He was told that the cell phone had to be turned over to Chester County detectives on the following day, Friday, August 23rd, or a search warrant would be issued. Attorney Ellison advised that he would comply but needed to schedule an emergency executive session with the full board, which was not scheduled to meet until the following Tuesday, August 27th, and at which time Attorney Ellison had planned to initially present the allegations against Mr. Como and Mr. Donato, as well as his preliminary investigative findings. The emergency executive session was scheduled that same evening, Thursday, August 22nd, and held the next morning, Friday, August 23rd, at approximately 9 a.m. During the August 23rd executive session, exactly 1 week after his initial contact with Dr. Taylor, Attorney Ellison briefed the full board for the first time regarding the allegations against Mr. Como and Mr. Donato, disclosed the existence of the unauthenticated transcript as well as a cell phone from which the transcript allegedly originated, and relayed the District Attorney's Office demand that the cell phone be relinquished to county detectives. Attorney Ellison also reported that though Mr. Como admitted exchanging some inappropriate texts and jokes, he did not authenticate the transcript. Attorney Ellison further advised that he had yet to fully review the transcript in Dr. Taylor's possession, but then given the District Attorney's interruption of his efforts to secure a forensic original, he would obtain a copy from Dr. Taylor, review it along with applicable legal research, and provide the board with a recommendation at its regularly scheduled executive session on Tuesday, August 27th. With the formal commencement of the school year just 2 days away, the board made no decision to alter Mr. Como's employment status pending Attorney Ellison's ongoing review, but instructed Attorney Ellison to expeditiously complete his review and analysis as soon as possible. Literally within hours, Attorney Ellison obtained a copy of the transcript from Dr. Taylor, began reviewing the first 17 pages in detail, and immediately contacted Vice President Ritter and me to advise that Mr. Como and Mr. Donato should be immediately placed on leave at their cost, pending his complete review of the entire transcript that weekend, Saturday, August 24th and Sunday, August 25th. Attorney Ellison's recommendations were communicated to the full board and accepted, and both men were immediately told that same day not to return work on Monday, August 26th. That weekend, Attorney Ellison completed his review of the transcript as well as the required legal research and analysis, and on Monday, August 26th, conferred with Mr. Ritter and me to advise that he would recommend termination to the board at its August 7th executive session, notwithstanding the fact that he was not yet able to authenticate the messages because the District Attorney's Office had yet to release a cell phone for forensic examination. Attorney Ellison prepared a condensed version of the transcript which contained only those pages where racially and sexually insensitive comments were allegedly exchanged between Mr. Donato and Mr. Como, and provided copies of the same to every board member the following day during the August 27th executive session. After reviewing the condensed transcript, the board immediately concluded that both men should be informed that they were being suspended without pay pending termination unless they elected to resign. In the case of Mr. Como, the board directed Attorney Elson to deliver its stated intention to him personally at his home following the regular public board meeting that night. Mr. Donato was contacted and so informed the following day. Both men elected to submit their resignations. Please, everybody, let me finish, okay? Let me get right to it. Let me get to the point. The exchanges were sickening. That two educators would believe or behave this way is just inexplicable and obviously unacceptable. They were in our front to our students, parents, educators, and the entire Coatesville community. The damage done to our community by these men cannot be calculated or measured. Like all of you, we are thoroughly disgusted and shocked by what they did. There aren't enough adjectives in the English language to describe the vile nature of their actions and words. These men were entrusted with the health, welfare, safety, and well-being. These men were entrusted with the health, welfare, safety, and well-being of our children. And they betrayed that trust by resorting to the lowest levels of depravity and hate. There hangs a banner which says, "Character is who you are when no one else is watching." By their actions, behind the perceived safety of a cell phone keypad, both of these men displayed character that this board decided it would not allow in the presence of its students on the opening day of school, no matter what the circumstances. As a result, they are now gone. At this point, I want to address two specific concerns that we have heard loud and clear from the community. One, why did the board release the messages? The simple answer is, as I stated previously, we could not authenticate the messages because the cell phone from which they allegedly originated was relinquished to the district attorney's office, and the messages were part of an ongoing criminal investigation. More importantly, however, we did not want these unauthenticated messages to poison the opening of the school year for 7,200 students and their families and define our district. These exchanges were so offensive and hurtful that I personally did not want to put this stuff out in our entire community, and no one on this board did either. Not to protect the people involved, but to protect our students. The second major question that people have, and understandably so, why didn't this board terminate their employment? Why were they allowed want to explain it, please. Why were they allowed to resign? The resignations of Mr. Como and Mr. Donato, which will be voted upon tonight, have been the subject of lively public debate, and rightfully so. We know that there will be a lengthy public comment on that issue this evening, and we welcome your views as always. But I want to make a minute to clear up a few misconceptions regarding the effects of a termination on a public employee's pension versus resignation. First, decisions regarding a school employee's ability to collect their pension are not made by the Coatesville Area School District. They are made by the Pennsylvania State Employees Retirement System. Second, whether Mr. Donato is fired or resigns, he will not collect a pension because he is not of retirement age. Getting to it. Whether Mr. Como is fired or resigns, he will be able to collect a pension because he is of retirement age. Fourth, there is no action that this board can take to deny Mr. Como his ability to retire and collect his pension because that process is solely controlled by the Pennsylvania School Employees Retirement System. Fifth, if at some point in the future criminal charges are brought against Mr. Como related to his employment and he is convicted, his pension may be forfeit at the time. But this board has no power whatsoever to deny or otherwise prevent Mr. Como from collecting his pension by firing him now. Lastly, Mr. Como will not receive 1 red cent of the remainder of his contract. Ladies and gentlemen, there will be no buyout. By law, these men cannot simply be terminated without due process. As public employees, we would be required to give them each a hearing from which they could exclude the public and afford each of them the opportunity to explain themselves, offer excuses, make spurious assertions, downplaying the seriousness of their actions and any number of defenses or explanations which could have been concocted by their legal representation. As you know, we did not want to hear this. This board was not interested in wasting its time, wasting taxpayer dollars and resources, or wasting our collective community's patience on hearing anything they had to say in defense of themselves. We did not want to hear a word, not a sound, other than the silence of their departure from this district and away from our kids as soon as possible. We wanted to focus our efforts on making sure that schools were operational and our kids were learning. Significant injury was inflicted by these men on our district. Our gaping wound was left as a result in allowing them to proceed through the lengthy termination process at significant legal costs, with the potential for multiple appeals would have simply inflicted additional injury, caused that wound to worsen, and delay our opportunity to heal and bring closure to this repulsive and repugnant situation. We have to set aside our emotions of anger, betrayal, and hurt, and focus on doing what we believe to be in the best interest of our students, our district, and our constituents by securing the resignations and getting these men out of here now. Doing so not only keeps our children safe and allows us to heal, but it enables us to minimize our legal liability in connection with the multiple lawsuits we expect to emerge, and protects the tax base of our constituents who may ultimately bear the burden of the legal costs and ramifications associated with this situation. We will be able to do this at a minimal legal cost and without buying out anyone's contract. Each of us sitting here this evening understand better than any reporter or camera person tonight the anger and pain that we all feel. This hurts. It has cut us to the bone, all of us. We are Coatesville. We are family. And we are hurting. But we will heal. We will recover. And we will rise. And that starts right now, tonight.